No confidence wishes to not fix where mandatory provisions has not been followed.
Tomorrow?
Yes, tomorrow.
ನಾಳೆ ಎಲ್ಲ ಕೊಡಿ. Give all the memos for tomorrow.
Election.
Total 4. ಕೊಡಿ ಅದು.
One matter. 2:30, my lord.
2:30 1 ನಿಮಿಷ ಮೇಡಮ್. ಅಲ್ಲಿ ಹೇರ್.
Let's fresh matters for tomorrow, my lord.
ನಾಳೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
Please.
2:30 ಬೇಕಾದ್ರೆ ಮಾತ್ರ ವೇಟ್ ಮಾಡಿ.
Election matter.
2:30 ಬೇಕಾದ? ಟುಮಾರೋಗೆಲ್ಲ ಕೊಡಿ.
Election.
With your lordship's kind leave, my lord.
Sir, one moment on the VC, one moment.
Please.
My lord. No matter, my lord.
Like 2:30 ಗೆ ಯಾರು ಬೇಕು?
Please.
ಏನು?
Motion of no confidence is tomorrow, my lord, therefore.
2:30. Yes,
Threat
sir.
of disposition.
Threat of
My lord,
2:30. Yes.
My lord, 2:30.
Election matter. Now there was an interim order.
Madam, ನಾಳೆಗೆ.
The counting was not down. There are batch of matters. There are 4 matters. May I request tomorrow? Be counsel.
2:30 ಬೇಕಾ ನಾಳೆ ಆಗ?
Nale.
ನಾಳೆ ಕೊಡಿ.
No confidence.
2:30.
ಇದು ನಾಳೆ ಸ್ವಾಮಿ.
ನಾಳೆಗೆಲ್ಲ ಕೊಡಿ.
My lord, 2:30. ನಿನ್ನೆ ಮೆಮೊ ಹಾಕಿದ್ ಮೊನ್ನೆ ಮೆಮೊ ಹಾಕಿದ್ದು ಸ್ವಾಮಿ, ಇವತ್ತು ಡೇಟ್ ಆಗಿಲ್ಲ. ಅದಕ್ಕೆ 1182 ಜನರು ಸ್ವಾಮಿ, ಇದು ಅದಕ್ಕೆ ಎಮರ್ಜೆನ್ಸಿ.
ಕೊಡಿ.
ಓಕೆ.
my lord,
27th ಬೇಕಾ?
my lord, the students are not being given hall tickets, my lord. Kindly be taken up 2:30, my lord.
Lord,
One matter for tomorrow, my lord.
ಟುಮಾರೋಗೆಲ್ಲ ಕೊಟ್ಬಿಡಿ.
Lord,
Tomorrow you give it.
Lord, total 4 matter.
Tomorrow no questions asked. Please give it.
Please.
ನಾಳೆಗಾದ್ರೆ give it. Fresh matter.
Fresh matter.
Give it. Yes.
My colleague is appearing through video conference, Lordship, Mr. Neeraj.
ಏನು?
Matter pertaining to the Dharwad bench. Matter.
I am at Dharwad
mentioning for
only.
Friday, my lord. Mentioning for Friday, my lord. The
All right,
urgency
give
is
it,
that,
sir.
my lord.
Yeah. Yes, sir.
Maybe taken tomorrow.
Taken?
Maybe taken tomorrow.
Give it. ಅಷ್ಟೇ ಅಲ್ಲ? ಒಂದು ನಿಮಿಷ. Maninder sir, there are 20 fresh matters. 5-10 minutes I'll finish them and then take it. Yes. ನಿಮ್ದು ಆಮೇಲೆ ಸರ್, ಅದಾದ್ಮೇಲೆ. Yes. Auction ಆಗೋಗಿ
I will demonstrate, my lord, with the help of the law laid down by the Honorable Apex Court, that there is virtually no scope for any objection.
Perjury.
I'm sorry, my lord.
Yes, sir.
There is no scope for, my lord, entertaining such objection because, my lord, the law laid down in my understanding is very clear. Now, my lord, your lordship may just take,
May I make one
just
submission?
take, I'm sorry.
It was set down for filing the objections.
No, no problem, sir. Just wait.
We-
Well, it's,
I am
we have
unable
filed,
to
My lord,
present the state.
I understand that objections are, we have objections filed.
but I'm sure, my lord, I can make one very humble request to my friend. Just permit me to say something on the basis of the Supreme Court judgment. Perhaps I would be able to demonstrate
No,
exercise.
that is precisely what I wanted to say. Once the pleadings are complete,
So
that
then,
I
please
think
read
it
it,
would
my
be.
lord, I'll show
but
it to you.
Malas, if it is put for
Because I have not even
pleadings
received the
and we have
copies
filed
of the
today, Malas,
statements.
Sir,
if we, it
Suppose
is
so.
put,
let him submit for 10
Very
minutes.
well.
Just permit me, my lord.
You don't have to worry.
I will leave there.
Now, my lord, just give me 2 minutes, my lord, because your
And
lordship
the
are
other
aware
matter,
of this
which is
matter.
parted,
That I will take.
that
Next.
that is also.
Video is taking time to on in this. So
After this, I will take.
I'm not able to respond.
My lord, your lordships are aware
Yes,
of the
Millie.
facts and the contours of this case, my lord, having dealt, and we have placed that judgment on record. Now, my lord, something more which is needed to be considered, my lord, with utmost respectful submission.
Yes, sir.
My lord, the principles which have been laid down, and my lord, I have heard this objection last time also, that a person concerned is not made a party before, my lord, a independent investigation is ordered. My lord, there are 5 circumstances which I have, my lord, been able to place my hands upon, where, my lord, nobody like this, a suspect or a potential accused, is not required to be made a party or require any hearing, my lord, in at least 4 situations. Just have a look
No,
at
no,
this.
let us, confine the submission to whether it should be interested or not. That is
I'm
the
only
case.
on that. I'm only on that. My lord, your lordship passed the order, the judgment, my lord, on 24th of September. Then, my lord, the action, the consequential action is taken by the learned trial court. And, my lord, a need is felt, my lord, which has now stood strengthened by the recent development which have taken place. My lord, the investigation must be fair and independent and must, my lord, inspire confidence. And the word used is, my lord, that the process must show a confidence that it will be taken up in the manner when it is required to. And, my lord, there are judgments where higher police officials, and if the politicians are involved, my lord, who are the accused and who are the suspect accused, my lord, the courts have felt that the reasonable apprehension is ex facie present, that the fairness would not be there. Therefore, there would be an utmost necessity for an independent investigation. Number 1. Number 2, my lord, your lordships, as per the prayer made, had required the loci to undertake the exercise so that, my lord, the immediacy of urgency of the collection of evidence, which must start immediately, has not started, and something, my lord, more adverse has happened, that some committee of 3 bureaucrats, they have taken over the records and they have taken over from the, my lord, the local police, and they have said that we will now do it. Now, my lord, just have a look at that, and I will then straight away come to, my lord, few judgment. My lord, a additional affidavit has been filed. Just permit me.
Which 3 officers have taken over?
I'll show to your lordship, my lord. It has, a note sheet has come, my lord. If your lordship may kindly see the view, why the local said, now I hold my hand, I can't do it because the 3 officers have come, the committee has taken over. Kindly just have a look at that, my lord.
No, 1
The-
minute. Yeah,
the
just 1 moment, sir. Venkatesh Arbati, sir. Investigation happened till today. Where are the records? Those records are here, but investigation that is continued till today. Is there. By the end of the day, you file it.
Your lordships give me time tomorrow or day.
Yeah.
Why?
ಅಯ್ಯೋ ಇದಾರೆ ಬಟ್
ಹಾ.
ಆತರ
ಯಾಕೆ ತಂದಿಲ್ಲ?
I did not, Lord, I'm sorry.
No, no, you should
I
have
should
got
have,
it.
I should have sought my lord's clarification on that because there is no, Lord, I did not, I'm sorry, Lord.
Anyway, you file it by,
I request my lord's permission.
because I also
Tomorrow,
want to go through it. You just give it by tomorrow, it should be here.
I will.
Yes.
Lord, these factors, these facts, I'm sorry, my lord, these facts which, my lord, in my respectful submission, the state ought to have placed, or these facts should have come, Lord, when your lordship rendered the judgment. There is an affidavit, my lord, which has been filed 18th of December 24, filed on behalf of the petitioner. I just want to read, my lord, a couple of paragraphs.
All right.
Kindly see, my lord, page 4 of the affidavit.
Yes. Affidavit dated?
Affidavit dated, my lord, 18th of December 24.
Papers ಕೊಡಿ ಮಾಡಿ. ಇಷ್ಟೇ ಬಂದಿರೋದು.
We have a spare copy also.
Give it. Get all the papers.
If your lordship may just see the start of the affidavit from page 2, my lord, the prayer in the present writ petition and some little background which is set out. And thereafter, my lord, kindly come to para 10, para 8 at page 4. Page 4, para 8. Just, my lord, I'll take your lordship 2 minutes to just run through these 2-3 paragraphs. I state that owing to the fact that the investigation is being conducted by Lokayuk Police Wing, who are under deputation from the state services, relationship between the officers, the state is in the nature of master and servant for the said reason. I apprehend that the crime would not result in an impartial investigation. Due to such concerns, I was constrained to file the present writ, my lord, for an independent investigation by CBI. Please see 10. Further, I state that immediately after the registration of crime and filing of the caption petition, respondent number 10 addressed a letter of 1/10/24 to Mysore Urban Development Authority, wherein she communicated that she intended to surrender all 14 sites that were allotted to her as alleged compensation. Such surrender of sites establishes the fact that she was indeed allotted the sites illegally and without any basis, and only gives credence to the fact that crime registered ought to be investigated. My lord, I'll put it a little higher for your lordship kind consideration, that this is the conclusive acceptance of committing the crime, that I made this crime, I earned this, my lord, generated this huge asset of, my lord, approximately 56 crore. Now, my lord, it is now under investigation, so I come forward and surrender it. Please see 11. I state the entire exercise of surrendering was done at the lightning speed. And please see, my lord, despite with these observations and the orders which have come, kindly see, my lord, the effort which are continuously ongoing, that, my lord, if a common citizen has to get either any release of land in notification, which is an impossibility, or, my lord, conversion of land from agriculture to non-agricultural use, etc., my lord, the same alacrity, my lord, your lordship will find a surrender is offered on a particular day and the entire state machinery is in action to accept that surrender. Please 11. I state that the entire exercise of surrendering the sites allotted to respondent number 10 was done at lightning speed. Muda commissioner, based on the representation made on 1/10/24, passed an order on the very same day, 1/10/24. And please see, my lord, your lordships have seen the land which was acquired, and, my lord, the acquisition, award, etc., everything having taken place, the land stood developed and distributed. The same land gets converted into non-agriculture, which is a non-existent land. The, my lord, developed plots which are given in that, my lord, Muda, development phase 3 in Vijayanagar or somewhere, my lord. Now on 110, 14 plots which are developed, which, my lord, is now the subject matter of a criminal investigation. The party come forward and surrendered it, and the state, my lord, in unison for that protective measure on the same day, my lord, which is placed on order on the record, my lord, in para 11. Same day it is accepted. Then, my lord, your lordship will see para 12. Conduct of respondent number 5 in trying to protect the respondent 9 to 12 is evident. It is only when the matter was listed on 5/11/24, respondent number 5 issued a notice to respondent number 9 asking him to appear. For a month, the respondent number 5 did not call upon the accused number 1 to give such statement. I state that the aforementioned fact would reveal the snail pace investigation. Kindly see, my lord, not instilling any assurance or confidence. 14. I state when things stood thus, the ED began investigation. And kindly come to, my lord, 15 and 16. My lord, the further, my lord, further colossal fraud which has taken place is mentioned in 15. Please see 16. I state that the Lokayukt had initiated suo motu proceeding against the officials of Muda regarding irregularities, administration in functioning of Muda, which was based on the report placed by respondent number 5 dated 6/24, and a search warrant was issued accordingly. However, the Lokayukta closed the suo motu proceedings since a parallel inquiry is initiated such that depicts that the local, despite taking suo motu cognizance of the alleged irregularities, have failed to acted copy of the same, my lord, is produced, and my lord, that this document, my lord, please come to page 29, this annexure. In this very, my lord, affidavit, kindly come to page 29. Kindly see the subject on the top. Suo motu proceeding as the officials of Mysuru Development Authority regarding the irregularities in the functioning on the basis of the report placed before me by the Superintendent of Police Karnataka, Mysuru, by way of report dated 6/6/24, alleging that there has been large-scale illegalities, maladministration, in the functioning of
Oh,
Mysuru.
it is closed because one-man inquiry commission is constituted and he is into.
Kindly see, my lord, the records are taken away. Please see that.
Who has taken away?
Yes, my lord, I'll show it to your lordships. Just 1 second, my lord.
They're with the court now.
Correct. It is. Yes, my lord. But what I'm saying is, my lord, Mysuru, which wanted to start and, my lord, taken a suo motu action. Please see, my lord, that the records which were taken at that point of time. Kindly see para 21. Your lordship will see, my lord, that the effort which were taken by the Lokayukta office suo motu in para 21 and 22. And after that, my lord, if your lordship may kindly come to page 36. Para 11, page 36. The Deputy Superintendent of Police Karnataka Loka Mysuru in his report has stated that before execution of the search warrant on 29/6, a 3-member committee headed by an IS officer of the Department of Urban Development has conducted surprise inspection of the Mysuru Development Authority and verified the files. Further, it is stated that team has seized more than 140 files from the said authority. As per the news item published in regional newspaper, Shri so-and-so Honorable Minister for Urban Development has issued statement that in respect of irregularities alleged to have committed at Mysuru Urban Development Authority with regard to allotment on 50/50, my lord, would be examined by the team of officers. In the said circumstances, the Deputy Superintendent of Police has reported that if inspection is conducted in execution of such warrant as the relevant records were already seized by the team of officers, it would not be possible to get the relevant record. Peruse the above note of the Deputy Superintendent of Police, Mysuru. The suo motu investigation was taken up on the basis of the report of the SP, Karnataka Loka Mysuru, that there are large-scale irregularities, maladministration, the functioning of MUDA, and that the government notification number dated so-and-so has been misused by the authority. Bulk allotment of sites have been made to the landowners and other illegalities have been committed. The report of Deputy Superintendent of Police discloses that already a team of officers headed by an IS officer of the Department of Urban Development of Government of Karnataka has conducted surprise inspection and seized the relevant record. Said team is further investigating the matter. According to the report, a single judge commission has been appointed, and therefore, my lord, the inquiry is closed. But something comes out which is extremely important in my respectful submission. If, my lord, the office of the Lokayukta had to conduct the inquiry which is initiated suo motu, first of all, my lord, itself does not, my lord, inspire any confidence that immediately at this time, the team of IS officers comes and take away all the files. Number one. Number two, my lord, if the exercise was to be undertaken in a bona fide manner, in accordance with the jurisdiction which is vested under the said enactment of Lokayukta, my lord, nothing had stopped the DSP of Lokayukta to now take those files away from that IS officer committee and take it into the custody of Lokayukta and proceed further. Please see, my lord,
No. Does that concern this particular allotment or this case?
my lord, therefore
It concerns the entire functioning of
It
MUDA,
may-
what I gather
my
from
lord,
here.
it
It
may,
does not concern the allotment made to the chief minister.
my lord, but supposing the investigation is carried out, the way, my lord, it is required to be carried out, and it shows, my lord, the scope and the width of fraud of such a manner that it requires further files to be investigated, my lord, that will become a part of the investigation. But, my lord, I am on the approach.
Yes.
With utmost respect, my lord, if the DSP had gone and he said these files have been taken away, he doesn't say that this doesn't deal with this cases. He says, I went there, I was told before I went there, an IS officer and two others had come and taken away the record. I therefore reported to you. The office of local, my lord, with utmost respect says, now hold my hands. And the period from June till now is lost. We do not know what happened to those 140 files. What happened before the files of the record, my lord, has come under the orders of this honorable court? We do not know. But the fact remains that no inquiry or no investigation of what its, my lord, concept has taken place. And there is a, my lord, my lord, in my respectful submission, an ex officio reluctance and the conduct demonstrating and establishing that of the authority, my lord, of the office of the Honorable Lokayukta, to, my lord, not to get inhibited by the fact that a IS officer with his team has taken away the files. They don't they may go away from one office. They don't go away from the jurisdiction of the Lokayukta. And it is a case of, my lord, impermissible refusal to exercise jurisdiction by that office. That's my respectful submission. And this document is a conclusive evidence which, my lord, does not require any opposition or objection to be, my lord, placed or considered by this honorable
Now,
court.
anyway, they have filed their objections. ನೀವು ಹಾಕಿದ್ದೀರಾ sir? ಅಲ್ಲ ಯಾರ್ದು objection?
My lord, appearing for the state. my
Request.
lord.
In fact, I have not received the copies of the objections filed by the other.
ಅಲ್ಲ,
I don't know who has filed it.
Whoever has filed. Now, heard you.
Nobody has
You
served a copy. And
exchange the objections or
yes,
whatever it
even
is.
the Lokayukta,
Ah.
which is the principal authority to
I
come
want the
before this.
records of investigation, one thing. I will pass some.
Lord, I want to take a little couple of more minutes.
This is
Now, with
all the
great
reason.
respect, absolutely irrelevant submissions are
my lord,
being made.
that
Like,
my
what
lord-
is- that was prior to the order of this honorable court.
course
What is
it is
its
prior to the
relevance?
order.
Absolutely
Of course.
irrelevant.
Well,
But
I
not
want to
with
say
order.
one thing.
ನೀವು
May I just say one thing, Malas?
ತೊಂದರೆನೇ ಇಲ್ಲ. I will. hear
Malas,
you on
what
the
is the
next date.
purpose of, with great respect, Malas, what is the purpose of these arguments? We have filed pleadings
I'm
today.
showing my purpose.
He
I have not
should-
shown
he
my
should-
purpose.
One second,
Now,
sir. He
I'm
should
going to
say,
show my
Malas,
purpose.
that he doesn't want to file a rejoinder, and then your lordship will
You-
fix the date.
ಈಗ- Now, sir,
Let him
one
say he
minute.
doesn't want to file a
Objections-
rejoinder.
Who is here?
Let him make that
Who's
statement.
Who is Dave sir?
Dr.
Singhvi, your video is not clear.
Singhvi sir, just one
Yeah.
moment. Now, Professor sir.
It's still not clear.
Objections ಗೆ rejoinder ಏನ್ ಹಾಕ್ಬೇಕು ಹಾಕಿ, whatever you want. I will pass an order. You just.
Lordship may kindly permit me to not pass.
First, you have to give all the records of investigation
I
that
do.
has happened till today. Yes, heard the learned senior counsel Maninder Singh appearing for the petitioner and all the senior counsel ಬರ್ಕೊಂಬಿಡಿ correct ಆಗಿ ಯಾರ್ಯಾರು appear ಆಗಿದ್ದಾರೆ. So and so.
Online,
Learned
online,
Online ಯಾರಿದ್ದಾರೆ ಎಲ್ಲ
online ಇದಾರಲ್ಲ.
ಅಲ್ಲಿ ಬೆಳಿ. Just make note of all that.
Please.
The learned senior counsel Maninder Singh, in support of the prayer made in the subject petition, refers to an additional affidavit and takes this court through the additional affidavit. The learned counsel, learned senior counsel, Professor Ravi Verma Kumar, submits that he has to, that the objections are yet to be served or pleadings are yet to get complete, and therefore it is not a stage at which the prayer would be considered. Therefore, the objections that are filed be, copy sir ಮಾಡಿದ್ದೀರಾ?
ನಾನು ಕೊಟ್ಟೇ ಇಲ್ಲ, ಯಾರು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
The objections or rejoinder of, that are filed in the case at hand shall be exchanged with the parties, exchanged with the parties forthwith. In the circumstances, I deem it appropriate to direct the Lokayukta to place the records of investigation conducted till today.
From
And
1912.
from 1912-2024 till today, so and so, before this court by tomorrow. Get it.
ಅಲ್ಲ, ನಮಗ್ ಕಾಪೀಸ್ ಕೊಡ್ಲಿ, ನಮ್ಗೆ ಅಲ್ಲಿ ಕಾಪೀಸ್ ಬೇಕಾಗಿದೆ. That is one reason why.
ಒಂದೇ ನಿಮಿಷ. So and so till today. The investigation by the Lokayukta shall continue. The investigation conducted by the, that is conducted by the Lokayukta will be overseen. What is your hierarchy? IG idara?
IG there.
will be overseen by the Inspector General of Police of the Lokayukta, and the report, if any, that is to be filed by the next date shall also be perused by the Additional Director General of Police of the Lokayukta, and the report, final or otherwise, shall be placed before this court on the next date for its perusal. The report shall be filed a day in advance before the next date of hearing. By then, the pleadings of whatever nature, be it the objections or the rejoinder, shall be complete. The matter would be heard further on the said date.
May I
Yes.
request permission to not
Lord,
submit.
on behalf of respondent number
copy.
12.
Yes,
Lord,
sir.
Objection is ready. My colleague is
File
in.
it, sir. Sir, you
Kindly
file
accept-
everything, exchange everything. Let the
Kindly.
investigation go on.
What
Let
date
the
is your
report be
lordship?
placed before this court.
Yes.
Yes, sir.
What date is your lordship giving, Malas?
23rd.
23rd. Very well.
Yes. List on 23rd. By
Very well.
22nd, you should, whether it is final or otherwise, you should place it before the court. All right?
No, 23rd, my lord, if it is convenient to your lordship.
23rd.
Can it be after the 25th, Madam, if
27th,
it's
there is
possible?
some
Ah.
23rd, sir, let me do it 23rd.
No, can we do it after the 25th, Madam, if it's possible?
All right, 27th.
All right, deeply.
27th, again at 10:30 AM. By
Very
then,
well.
the entire thing should be here.
Thank you. Obliged.
Next date before the trial court is 28th.
No, that is why I have to do it before 27th. That is why 28th. I'll take it. I'll pass
Precisely
an
why I
order.
asked for 27th, because 28th
28th.
is the
I have
deadline set
extended
for
the date up to 28th. That is the reason I
That's
want.
precisely why I requested.
Yes.
27th.
27th.
Grateful.
That should be fine, sir.
That's fine. Thank
What
you.
is that? ಎಲ್ಲ file ಮಾಡಿ, file it in the registry.
Equal.
Copies
R11
ಎಲ್ಲ
must
exchange ಮಾಡಿ, file it in the registry. I'll take it on 27th.
Submitted. May I request?
ಅಲ್ಲ ರಿಜಿಸ್ಟ್ರಿ ಫೈಲ್ ಮಾಡಿ.
ಕೊಡಿ, ಆಯ್ತು ಕೊಡಿ. Learned counsel for the Lokayukta, Venkatesh Arbatti, files a statement of objections. The same is taken on record.
Great.
ಅಷ್ಟೇ. ಯಾರಾದ್ರೂ ಇದ್ರೆ ಕೊಡಿ, I will take it on record. Anybody else's objections are here?
Yes.
ಫೈಲ್ ಮಾಡ್ಲಿಕ್ಕೆ
R11. 12, they are on here. Mr. Aditya Narayan, please just hand over the objections.
Where is he? It's here.
My colleague is
Learned
before your
counsel,
lordship.
Aditya Narayan, representing the 12th respondent, also files his objections.
Copy.
Same is taken on record. Copies of the same be exchanged with all the counsels representing the respective parties in the case at hand. Yes.
Lordship. Grateful.
Also
R11,
my lords. Back on 27th.
Yes, sir.
And this IA copy we don't have, but I'll ask my friend.
Please
Everything,
exchange
everything.
all that you want to
Please give
exchange.
everything.
But the investigation will continue.
Very well.
And this is the order that I have passed is there. Yes.
Grateful.
Because I want to peruse the papers and then decide on something. Yes.
Please.
Obliged. Grateful.
Grateful.
27th.
Please.
Yes. ಅದು ಇನ್ನೊಂದು ತಗೊಳ್ಳಿ.
Ordered matter.
List on 27th for further hearing. No problem, right? Heard in part.
Now I am served.
Heard in part. List the matter on 27th at 10:30 AM for further hearing. Yes. ಇಲ್ಲ, ಅದು ಇನ್ನೊಂದು ಇದೆಯಲ್ಲ, ಯಡಿಯೂರಪ್ಪ ಅವರು ನೋಡಿ. ನೀವು ಮುಗಿಸ್ಬಿಡಿ ಸರ್ ಅದು.
ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
ಎಸ್.
Other matters ಮೇಲೆ 12.
ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
May I please?
Yes.
I appear for the response.
Yes.
Now the I have two preliminary objections to the maintainability of the writ petition itself. Before I take the court to the facts, may I request the court to kindly peruse the act for a minute?
POCSO.
POCSO.
POCSO Act ಕೊಡಿ ಮೇಡಮ್.
POCSO. Correct. 2012 Act. Chronological ಆಗಿ ಇಟ್ಕೊಂಡ್ಬಿಡಿ ಸ್ವಲ್ಪ.
ಇಲ್ಲಿ ಡಿಫಿಕಲ್ಟ್. ನಿಮ್ದೇ ಇದ್ರೆ ಕೊಡಿ.
ನಮ್ದೇ ಕೊಡಿ.
ಅದು 482 ಕೋಟ್ಲಿ ಇರುತ್ತೆಲ್ಲ. ಎಸ್.
The allegation against the accused, number 1, is under section 7 and 8. Kindly permit me to read the two.
Yes.
provisions. Comes under the section
Sexual harassment.
sexual assault
Yes.
and punishment therefore. Sexual assault,
Yes.
section 7.
Yes.
Whoever with sexual intent, kindly mark it. This is one of the requirements, mental, this thing. With sexual intent, touches the vagina, penis, anus, or breast of the child, or makes the child to touch the vagina, penis, anus, or breast of such person or any other person, or does any other act with sexual intent, which involves physical contact without penetration, he is said to commit sexual assault. Now, the punishment is prescribed under section 8. Now, two very important sections. to be
ಇದರಲ್ಲಿ
noted.
one of the instance is what the petitioner is alleged of performing.
Obliged. Kindly permit me to show two more provisions, namely section 29. Unlike the normal
Yes, sir.
foundation for criminal jurisprudence,
Yes.
that a man is presumed to be innocent. Here is a provision under section 29, where a person is prosecuted for committing or abetting or attempting to commit any offense
No, this
under
is
sections 3.
reverse burden here.
Yes. 7, the special court shall presume that such person has committed or abetted or attempted to commit the offense, as the case may be, unless the contrary is proved. So when is the contrary proved? It can be proved only at the trial. This is a rebuttable presumption. This is not a conclusive
Correct.
rebuttable presumption. Now, section 30 also may kindly be seen. So this is with reference to the offense. He is presumed to be guilty when this thing is prosecuted. Mere prosecution is evident. Section 30 may kindly be seen. Presumption of culpable mental state, because here he is required to touch with a sexual intent, whether it was an affectionate hug, whether it was an affectionate this thing, or it was
If
with
the
a sexual.
allegations are seen, it cannot be a good touch at all. Yes. Allegation.
30.
Prima
Now,
facie.
the reason why I am insisting on these two provisions is the presumption of a culpable mental state in any prosecution for any offense under this act, which requires a culpable mental state on the part of the accused, the special court shall presume the existence of such mental state, but it shall be a defense for the accused to prove the fact that he had no such mental state with respect to the act charged as an offense in that prosecution. So it is at the trial that he can establish, can step into the witness box, because there is nobody else who has seen it, and there is nobody else who is a witness to it.
There is no eyewitness.
Eyewitness, except the victim, who has sworn to the fact that she was molested. Okay. Now, having said this, so there is a presumption, statutory presumption in favor of the guilt of the accused. There is a statutory favor in favor of presumption that it was done with sexual intent. These two presumptions are there, and the act, kindly come to the preamble of the act for a minute. Only one sentence I'll.
Yes.
Last but one sentence before the commencement of the project, be it enacted by Parliament so and so. Before that, one sentence may be seen. And whereas sexual exploitation and sexual abuse of children are heinous crimes and need to be effected. So this has Parliament itself has declared that it is a heinous.
There can be no qualm about that.
It is a heinous crime.
Yes.
So it is in this backdrop, my very respectful submission is, in the light of the presumption, that a 482 petition does not lie in respect of cases under POCSO for the reason that there is a statutory presumption and he is presumed to be guilty. Once he is prosecuted,
Reverse burden.
yeah, he is presumed to be guilty. Even the sexual intent is presumed under section 30. So this being said, that is the first objection I have for the maintainability of it. Now, I would also request the court to kindly find out from the evidence I have already placed before the court that the prosecution has made out a strong foolproof case that there exists a prima facie case. Unless he rebuts these presumptions, he'll not be. In order to demonstrate the prima facie nature, kindly permit me to show the statements made by the victim.
Victim, yes. Page. ಅವರೇನೋ ಕಂಪೈಲೇಷನ್ ಹಾಕಿದಾರಲ್ಲ ಅದ್ರಲ್ಲಿ ಇದೆಯಾ?
Lokaयुक्त has, I mean, SIT has filed the charge sheet put here.
ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ಇದೆ.
Charge sheet.
Yes, yes. Charge sheet is here. ಬೇರೆ ಇದೆಯಾ?
ಹೌದು. Now, neatly bound copies are given so that the pages tally.
ಚಾರ್ಜ್ ಶೀಟ್ is here anyway, but ಕೊಡಿ ಅದು.
Charge sheet.
ಇದೆ ಚಾರ್ಜ್. This page.
Page 164. Is the statement of the victim. I'll not trouble the court with the first volume made.
ಪ್ರಶ್ನಾವಳಿಗಳು.
Oh, sorry. 208. Page 208 may contribute.
208, yes. That's the victim state.
Yeah, this is the victim statement. I am straight away taking the court because victim is the only witness to this incident and she is the victim. Para 2 at page 209 may kindly be seen.
Yes.
Later on, Sri Yediyurappa called me inside. At that time, my mother asked whether she too be permitted to come inside or not. At that time, he instructed my mother to be outside. Kindly mark this. So the guilty mind starts working. That is where it starts working. At that time, I thought that during inquiry of the previous POCSO case, I have been inquired privately. So I thought like that only. So the girl thinks that it was for this reason. At that time, my mother also instructed me to give case details properly. Accordingly, I followed Mr. Yediyurappa. I went to one room which was situated beside the hall, in which few sofas and few tables were there. Immediately after entering the room, Sri Yediyurappa locked the door with the key. Kindly mark it. He locks the door, locking the girl inside the room. By observing this locking process, I thought why he is locking the door. He approached near me, asked, am I able to identify the culprits of previous case? I say yes loudly. At that time, again, he asked about my age at the time of committal of the previous offense. I told 6.5 years old. Again, I repeated this word as he had not heard it properly. While repeating my age factor second time.
ಅದು ಓದೋದು ಬೇಡ.
ಓದೋದು ಬೇಡ.
ಯಾಕೆ? It's unreadable. Yeah.
That all the gory details are given out by the girl herself. Now this is what happened, and this is the offense reported to the police also by the mother, because the mother did not know what is happening inside, and the child comes out crying. after she protests against what happened and directs him to open the lock. Pursuant to that, he opens the lock, lets out the child.
One thing, why you did not register the crime on that day itself?
Sorry,
On that day, 2/2/2023 is the
Yeah.
date of the incident.
incident.
Crime is registered on 14/3/20.
I
Why is
respect,
that?
I
That's all.
respect. That also I will explain.
Ah.
I'll duly explain that. Now, now it is after that she comes out. The mother thinks after narrating because when she was 6.5 years old, the husband's relative rapes this child at home.
That is first
That is the
POCSO case.
first
POCSO case.
POCSO case, and it is to get justice in that case, she has approached the accused.
Yes, that is the narration.
Yes. So it is, for that reason she had gone. And while seeking justice in that case, this is the treatment method. So thinking that the mother thought the child has become emotional because she recollected the gory details of her past. And therefore, she was in tears. As they step out, the child holds the mother's hand and tells the mother, Amma, I have something to tell you. Then, very close by, there is a Starbucks coffee shop. They don't enter the coffee shop. On the footsteps of the coffee shop, mother and child sit, and the child narrates what happened to her in the room. Immediately, the mother rushes back
To the petitioner.
to the petitioner and confronts him. Now, those details are given by the child. Para 4,
Where?
para 4, page 211.
After crossing their gate.
After crossing their gate, my mother was little bit ahead. I was following my mother, called her Amma. She turned back, asked me what happened. At that time, I requested my mother to go to Starbucks coffee shop, existing adjoining to Yediyurappa's house. Accordingly, we went there. By sitting outside of that coffee shop, I narrated the entire incident that has taken place inside the room of Yediyurappa's house. After hearing of the said incident, my mother got stunned. And again, we went back to Yediyurappa's house to confront about that incident. Then we went inside the gate of Sri Yediyurappa's house. Gunman man Aradhya, who sat near the main door, asked me what had happened. My mother replied again, we want to meet Yediyurappa. Then the gunman instructed us to wait for some time as Yediyurappa was meeting with some other persons. Meanwhile, my mother went inside within the compound itself and made a phone call to one lawyer by name R.R. Hiraman. Narrated the entire incident. At that time, I was standing near my mother. My mother told that the above said counsel has instructed us to talk calmly. Thereafter, my mother came to me, took out the cash from the bag which was given by Yediyurappa, and we took one selfie with that cash. I forgot to mention this. Now, immediately after the girl protested in the room, the accused takes out cash and thrusts in the hands of the child. And after they come out, again he pays some more money to the mother. Now, this is what she has narrated. So, when my mother was talking in phone, at that time, I was thinking that it is the previous case the police officials and public have asked me and my mother about evidence to prove the incident. Hence, at this time also, I thought that the officials may ask me about the evidence of the present incident. Then I made up my mind to record that the conversation to be held with the above said Yediyurappa. Then, without the knowledge of my mother, after taking up selfie with cash, the persons who were in the meeting came out. Then, while entering inside, I set my phone for recording. The persons who came outside known by my mother, and my mother spoke with them and requested them to be there only till we come out. Accordingly, we entered the house. At that time, Yediyurappa was watching the TV. My mother asked him what he has done with her daughter inside that room.
Yes, sir.
My mother asked him what he has done with her daughter inside that room. Yediyurappa replied to my mother that I am just like his granddaughter.
Yes.
Immediately, my mother raised the question, if it is like so, why did you put your hand in her shirt or blouse? So I'll avoid that. But the fact of the matter is, the whole conversation was recorded by this girl
Where do I get that?
without the knowledge.
Where do I get that?
I'll place it immediately. Without the knowledge of her mother. And this is
The conversation inside the room or outside?
sorry.
And the conversation that is recorded is inside the room at the first instance or when she came outside?
No, it is when they re-entered the house.
Re-entered.
First time she never suspected the bona
Suspect
fides of
to
the
record it.
petitioner. She never suspected. She thought he's only getting the details of the POCSO case. So it is in this backdrop. Now, what is very important to take note of is, now this conversation was recorded in a, which is that mobile? POCO mobile. POCO mobile. And the man who bought this mobile for her was her own brother, which fact has also come on record and it is established. Now thereafterwards, she uploads the video recording to her Google Drive, which is a documented.
That's what I see here.
Yeah.
In the statement.
To her Google Drive, she immediately uploads after the conversation was recorded. And
so in that recording of the conversation,
yes,
there is reference to what the petitioner did with the daughter inside.
direct reference.
That's all.
Kindly come to page 136. Straight away, I'll take the court. Page 134, 21/3/2024.
Oh, ಇದು ಅವತ್ತು ಹೋದ್ರಲ್ಲ. Page 136.
Page 135 is the request that this is the request made to the FSL seeking a report. Now kindly come to the statement actually, page 136 may kindly be perused. I will not read out the names because the identity of the victim should not be disclosed. So, she'll they enter. One nimsha meet ಮಾಡ್ಬಿಡೋಣ. One nimsha iri. One nimsha. ಹೋಗ್ ಬನ್ನಿ. So this is what Aradhya tells her. ಹೋಗ್ ಬನ್ನಿ. ಇಲ್ಲೇ ಇರಿ. ಅಪ್ಪಾಜಿ, ಇಲ್ಲೇ ಇದ್ರ ಅಪ್ಪಾಜಿ? ಏನ್ ಮಾಡಿದ್ರಿ ನೀವು? ಒಳಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿ. This is the first question. ಒಳಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿ ಏನ್ ಮಾಡಿದ್ರಿ ಅಪ್ಪಾಜಿ? Second question. ಕೇಳು ಏನ್ ಮಾಡ್ದೆ ಅಂತ. ನನ್ನ ಮೊಮ್ಮಗಳ ಇದ್ದಂಗೆ ಅವಳು.
Yes.
So the complainant says, ಒಳಗೆ ಬ್ಲೌಸ್ ಒಳಗೆ ಕೈ ಹಾಕಿದ್ರಂತಲ್ಲ ಅಪ್ಪಾಜಿ.
ಬೇಡ. So according to you, if that incident has not happened, why would she question in this manner is what you say?
Yeah, no, directly. And no, more important factor is he admits this fact.
Yes, check ಮಾಡಿದೆ.
ಹೌದು. ಇಲ್ಲ ಮರಿ ಅಂತಾರೆ.
ಅದು ಕರೆಕ್ಟ್.
ಅಪ್ಪಾಜಿ ಎಲ್ಲರೂ ಹಿಂಗೇನಾ ದೌರ್ಜನ್ಯ ಮಾಡೋದು?
ಸೆಕೆಂಡ್ ಕ್ವೆಶ್ಚನ್ ಇದೆ.
ಹಾ, ಎಲ್ಲರೂ ಹಿಂಗೇನಾ ದೌರ್ಜನ್ಯ ಮಾಡೋದು? So the petitioner responds, ನನ್ನ ಮೊಮ್ಮಗಳಿದ್ದಂಗೆ ತುಂಬಾ ಒಳ್ಳೆ ಹುಡುಗಿ, ಚೆಕ್ ಮಾಡದೆ ಅವಳಿಗೆ ಮುಂದಕ್ಕೆ ಒಳ್ಳೇದಾಗತ್ತೆ. So he admits that he did it. ಅದು ಏನ್ ಬೇಕೋ ನಾನು ಸಹಾಯ ಮಾಡ್ತೀನಿ. ಚೆನ್ನಾಗಿ ಅವಳನ್ನ ನೋಡ್ಕೊ
That I have seen.
ಅಷ್ಟೇ.
Yes.
ಹೀಗೆ ಸಹಾಯ ಮಾಡ್ತೀರಾ? 9 ವರ್ಷದಿಂದ ಹೋರಾಟ.
This is the recorded transcript on the mobile.
Sorry.
Recorded transcript of the conversation
Ah.
on the mobile.
Yeah, this is the recorded. And what is very important factor is he appreciates the victim. Page 138, first sentence.
Yes.
Page 138.
Yes.
Top of the page. ನಾನು ಹೇಳ್ತೀನಿ ಕೇಳು, ಬಹಳ ಒಳ್ಳೆ ಹುಡುಗಿ ಅವಳು. ನಾನು ನೋಡ್ದೆ, ಚೆಕ್ ಮಾಡ್ದೆ, ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಸಹ ಯಾರೊಬ್ರಿಗೂ ಬಿಟ್ಕೊಡಲ್ಲ. ಚೆನ್ನಾಗಿ ಬೆಳೆಸು, ನಾನೇನೇನ್ ಬೇಕೋ ನಾನು ಮಾಡ್ತೀನಿ, ಇದನ್ನ ಪ್ರಯತ್ನ ಮಾಡ್ತೀನಿ. So once again, appreciation because of the malafides and other things attributed, it becomes necessary to point out this. Last sentence in the same page, kindly be perused. He tells the mother, page 138. ನಿನ್ನ ನೋವು ಗೊತ್ತಾಗುತ್ತೆ, ಇಂಟೆಲಿಜೆಂಟ್ ಇದೆಯಾ, ಸೊ ಹಿ ಅಪ್ರಿಷಿಯೇಟ್ಸ್ ದಿ ಮದರ್. A to Z ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದೀಯಾ, ಅವಳು ಒಳ್ಳೆ ಹುಡುಗಿ, ಬೆಳೆಸು, ಗೊತ್ತಾಯ್ತಾ, ಯಾವ ಕಾರಣಕ್ಕೂ ನಿನಗೆ ತೊಂದರೆ ಮಾಡಲ್ಲ, ಸರಿ ಮಾಡ್ಸೋಣ. ಸೊ ದೆನ್ ನೆಕ್ಸ್ಟ್ ಪೇಜ್, he rings up D.K. Shivkumar. I thought they're no, I thought they're politically at loggerheads till I read this conversation.
That's all right. All are friends, except on the field. Yes.
And then page 1, again, he appreciates her, ಒಳ್ಳೆ ಹುಡುಗಿ, ಅವಳು ಒಳ್ಳೆ ಹುಡುಗಿ. Page, bottom of the page. ಆಮೇಲೆ he compliments the complainant also. ಅದು D.K. ಶಿವಕುಮಾರ್ ತಗೊಳಪ್ಪ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಕಾಮೆಂಟ್ ಕೈಂಡ್ಲಿ ಬಿ perused.
Yes.
The complainant was appreciated by the petitioner. ಆದರೆ ನೀನು ಹಠವಾದಿ ಕಣಮ್ಮ, ಮೆಚ್ಚಬೇಕು ನಿನ್ನ. Sir, no political motives were attributed.
No political motives.
ಇವಾಗ ಪೆಟಿಷನ್ ತುಂಬಾ ಅದು ಬರ್ದಿದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ
Petition ತುಂಬಾ. Petition ಅಲ್ಲಿ ಬರ್ದಿರೋದು. ಈ ಕ್ವೆಶ್ಚನ್ ಆನ್ಸರ್ ಯಾವ ಪೊಲಿಟಿಕಲ್ ಮೋಟಿವ್
ಇಲ್ಲ ಇಲ್ಲ. 139 ಬಾಟಮ್, ಅಗೈನ್ ವಿಕ್ಟಿಮ್ ಒಳ್ಳೆ ಹುಡುಗಿ. 140, I don't know why he makes this comment. He petitioner says his first answer to the question, ಕಲರ್ಫುಲ್ ಆಗಿ ಇರಬೇಕು ಮತ್ತೆ ಒಳ್ಳೆ ಹುಡುಗಿ ಯಾವ್ದಕ್ಕೂ. I don't know why he made that statement. Anyway,
it is the conversation that is recorded.
Yes.
Transcript of that recording.
Transcript is.
Yes. Next. Based upon.
Now, then the petitioner collects the phone number of the complainant. Page 141. She says her phone is lost. Somebody has stolen it. So ಅದಕ್ಕೆ ಮತ್ತೆ ನಿನ್ನ ಹತ್ರ ಯಾವ ನಂಬರ್ ಇದೆ ಮರಿ? ಅದೇ ಇವಳ ನಂಬರೇ ನನ್ನ ಇನ್ನೊಂದು ನಂಬರು ಕೊಡು, ಅದನ್ನು ಯಾವುದು ಕೊಡು. ಸೊ he demands and obtains the mobile number. So the mobile number is given. CW12, whose statement was read over by my learned friend Aradhya anta. He is the man who collected the phone number, and it is he who connects all the phone connections to the accused whenever a phone call is made. So his name has repeatedly come, and thereafterwards he collects the details that earlier also this lady had contacted him. Then he sends them to the police commission. Now, this fact that the recorded conversation, the transcript of which I have just now read, has been proved to the hilt. Number one, the sample of the accused was collected. and sent for verification. And it matches with the voice sample of the accused. And that fact is borne out by the
The FSL report ಅಲ್ಲಿ
ಇದೆ.
page.
kindly come to page 570. 570. 570 to 579, volume 2. Volume 2. Please come to page 572. Bottom of the page.
Yes, are similar.
Yeah. The words selected for substantial analysis are mentioned below. ತುಂಬಾ ಒಳ್ಳೆ ಹುಡುಗಿ ಅವಳು, ನೋಡ್ದೆ ನಾನು, ಚೆನ್ನಾಗಿ ಬೆಳೆಸು, ಬಹಳ ಒಳ್ಳೆ ಹುಡುಗಿ ಅವಳು, ನಾನು ಯಾರೊಬ್ರಿಗೂ ನಾನು ಹೇಳ್ತೀನಿ ಕೇಳು, ನಾನು ಪ್ರಯತ್ನ ಮಾಡ್ತೀನಿ, ನನ್ನ ಮೊಮ್ಮಗಳಿದ್ದಂಗೆ. So this voice
Matches.
is compared. Yes.
Is similar is what is said.
Yes. The comparison of respective voices based on auditory and feature extraction methods have revealed the respective speeches said to be of male
So,
speaker.
of both the victim and the petitioner, it's confirmed.
Yes, confirmed. That is confirmed.
Yes.
So all the other details are also, technical details are also available in the following pages,
Yes, that is there.
up to page 579.
Hmm.
Then, is this video marked? Is this video not a genuine one?
Hmm.
For this purpose, the video FSL report at page 592 may 582 may kindly be seen. 580.
Certificate.
Yeah. 582.
Yes.
The opinion at page 585.
Yes. I've seen.
Yeah. Yes. So it is certified to be genuine and it is certified to be not marked.
Yes.
Then the mobile phone was sent to the National Forensic Science University of Gujarat
ಅದು report ಇದೆಯಾ? Page.
for verification, page 550. While coming to the court, I saw there is a Forensic Science University.
ಪಕ್ಕದಲ್ಲಿದೆ.
I hope hereafter.
The IIM campus ಪಕ್ಕದಲ್ಲಿದೆ.
Yes.
AIT. Yes, next. National Forensic Science Laboratory branches here.
I think original this thing is at Gujarat.
Gujarat.
So the device that was sent, one mobile phone make POCO. POCO was the one used by the girl.
Yes.
Model, etc. All the details
These are
given.
reports there.
Yeah. Now that was sent for verification, and the opinion is
now the only issue is 161 statement ತಗೊಂಡು we should not entertain 480.
yes.
These are quite clinching, but the law, because so many judgments are given.
Yes. So I'm showing this and only one more. I'll trouble the court with only one more document.
Yes.
Namely, the petitioner was interrogated.
Oh, where is
And
that?
this honorable court monitored it. That is available. Kindly come to the interrogation transcript. This is done after the court directed the interrogation to be done.
ಸ್ವಾಮಿನಿ ಮೇಡಮ್ ಎಲ್ಲ ಬರ್ಕೊಂತ ಇದ್ದಾರೆ.
The only thing, the pages are not tallying with us.
But anyway, just check it
Volume,
when you brief senior.
volume 2, 492 may kindly be seen.
492.
492.
ಪ್ರಶ್ನೆಗಳು. This is interrogating the petitioner.
Yes, petitioner's interrogation.
All right.
Para question number 8 may kindly be perused. ಕಂಪ್ಲೇಂಟ್ ನಿಮ್ಗೆ ಎಷ್ಟು ವರ್ಷಗಳಿಂದ ಪರಿಚಯ? 7-8 ವರ್ಷಗಳಿಂದ ಪರಿಚಯ ಇರ್ತಾರೆ. 493 ಎಷ್ಟು ಸಲ ಭೇಟಿ ಆಗಿರ್ತಾರೆ? He admits she has met him number of times. 14 may kindly be seen.
Yes.
ತನ್ನ ಮಗಳು ಪೋಕ್ಸೋ ಪ್ರಕರಣದಲ್ಲಿ ನೊಂದ ಸಾಕ್ಷಿಯಾಗಿದ್ದು ಯಾರ ವಿರುದ್ಧ SITಗೆ ನನ್ನ ಪ್ರಕರಣವನ್ನು ವಿಚಾರಣೆಗೆ ಕೊಡುವಂತೆ ಕೇಳುತ್ತಿದ್ದರು? His answer is ಮಹಂತ ಸಿಂಗ್ ಅವರು ತನಗಾದ ಅನ್ಯಾಯದ ಬಗ್ಗೆ SIT ಮಾಡಿ ತನಿಖೆ ಕೈಗೊಳ್ಳುವಂತೆ ಕೇಳಿರುತ್ತಾರೆ.
Yes.
15 2/2/24 ಕಂಪ್ಲೇಂಟ್ ತನ್ನ ಮಗಳ ಜೊತೆ ನಿಮ್ಮ ಮನೆಗೆ ಬಂದಾಗ ಯಾವ ವಿಷಯದಲ್ಲಿ ವಿನಂತಿಸಿರುತ್ತಾರೆ? ಆನ್ಸರ್: ನನ್ನ ಮಗಳಿಗೆ ಸುಮಾರು 9 ವರ್ಷಗಳ ಹಿಂದೆ ಸಂಬಂಧಿಕನಿಂದ ಅತ್ಯಾಚಾರವಾದ ಬಗ್ಗೆ ಇದುವರೆಗೂ ನ್ಯಾಯ ದೊರೆತಿಲ್ಲ. ಟ್ರೇಡಿಂಗ್ನಲ್ಲಿ 4-5 ಸಾವಿರ ಕೋಟಿ ಮೋಸ ಆಗಿರುವ ಬಗ್ಗೆ ನ್ಯಾಯಗೊಳಿಸುವಂತೆ ಕೇಳಿದರು. ಕಂಪ್ಲೇಂಟ್ ನೆಕ್ಸ್ಟ್. ಕಂಪ್ಲೇಂಟ್ ಮಗಳಿಗೆ ಎಷ್ಟು ಹಣ ರೂಮಿನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಿ? ಹಣ ಕೊಡಲು ಕಾರಣ?
ಹಾಲಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ. That's what he said.
ರೂಮಿನಲ್ಲಿ ಅಲ್ಲ, ಹಾಲ್ನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೆ.
ಅದೇ.
ಅದು ತೊಂದರೆಯಲ್ಲಿ ಇರುವುದಾಗಿ ತಿಳಿಸಿ ಕಣ್ಣೀರು ಹಾಕುತ್ತಾ ಇದ್ದುದರಿಂದ ಸಮಯದಲ್ಲಿ ಇದ್ದ 8-9 ಸಾವಿರ 9 ಸಾವಿರ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಕ್ಸಾಕ್ಟ್ ಅಮೌಂಟ್ 9 ಸಾವಿರ ಹಣವನ್ನು ಕೊಟ್ಟಿರ್ತೇನೆ. ಸೊ ದಿಸ್ ಇಸ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ದಿ ಇನ್ಸಿಡೆಂಟ್.
Question number 18.
17th ಒಂದು ನಿಮಿಷ.
17 ನೋಡೋಣ.
ಯಾಕೆಂದ್ರೆ ಪೊಲಿಟಿಕಲಿ ಮೋಟಿವೇಟೆಡ್ ಅಂತ
ಆಗಬಹುದೇನೋ.
ಆಡಳಿತ ಪಕ್ಷದ ರಾಜಕಾರಣಿ ಬಿಟ್ಟು ನಿಮ್ಮ ಹತ್ರ ಸಹಾಯ ಕೇಳಲು ಯಾಕೆ ಬಂದ್ರು? ನಾನು ಒಬ್ಬ ಮಾಜಿ ಮುಖ್ಯಮಂತ್ರಿ ಆಗಿದ್ದು ನನ್ನಿಂದ ಏನಾದರೂ ಸಹಾಯ ಆಗ್ಬಹುದು ಅಂತ ಬಂದಿದ್ದಾರೆ. 21 ಒಂದು ನಿಮಿಷ.
ಎಸ್.
ಕೈ ಹಿಡಿಯೋದ್ರ ಬಗ್ಗೆ 18.
ಅದೇ 18
ಮತ್ತೆ ಅವರ ಮಗಳ ಕೈ ಹಿಡಿಯಲು ಕಾರಣವೇನು? ಮಗುವಿಗೆ ಆದ ಅನ್ಯಾಯದ ಬಗ್ಗೆ ವಿಚಾರಿಸಲು ಆಕೆಯ ಕೈಯನ್ನು ಹಿಡಿದುಕೊಂಡು ಮಾತನಾಡಿಸಿರುತ್ತೇನೆ. ನೋ ದಿಸ್ ಇಸ್ ದಿ ವರ್ಷನ್ ಆಫ್ ದಿ ವಿಕ್ಟಿಮ್ ದಟ್ ಹಿ ವಾಸ್ ಹೋಲ್ಡಿಂಗ್ ಹರ್ ಹ್ಯಾಂಡ್. 21 2/2/24 ಎರಡನೇ ಬಾರಿ ಬಂದಾಗ ನಿಮ್ಮನ್ನು ನನ್ನ ಮಗಳಿಗೆ ಏನ್ ಮಾಡಿದ್ದೀರಿ ಅಂತ ಕೇಳಿದಾಗ ಏನು ಉತ್ತರ ಕೊಟ್ರಿ? ಯಾಕಮ್ಮ, ಏನಾಗಿದೆ, ನಾನೇನ್ ಮಾಡಿದೆ, ಹುಚ್ಚುಚ್ಚಾಗಿ ಏನೇನೋ ಮಾತಾಡಬೇಡ ಅಂತ ಹೇಳಿರುತ್ತೇನೆ. ದೆನ್ 23 ನಿಮ್ಮ ವಿರುದ್ಧ ಫೇಸ್ಬುಕ್ ಮತ್ತು ಸೋಷಿಯಲ್ ಮೀಡಿಯಾದಲ್ಲಿ ವಿಡಿಯೋವನ್ನು ಬಿತ್ತರಿಸಿದ್ದು ನಿಮಗೆ ಯಾವಾಗ ಗೊತ್ತಾಯಿತು? ಟಿವಿ ಮಾಧ್ಯಮಗಳಲ್ಲಿ ಬಂದ ಮೇಲೆ ತಿಳಿಯಿತು. ಆದರೆ ಅದರ ಬಗ್ಗೆ ಯಾವುದೇ ಕ್ರಮವನ್ನು ತೆಗೆದುಕೊಂಡಿಲ್ಲ. ಕೈಂಡ್ಲಿ ಮಾರ್ಕ್ ಇಟ್. He has not instituted any proceeding against her for 26 may kindly be perused.
Yes.
ಅರುಣ, ರುದ್ರೇಶ, ಮರಿಸ್ವಾಮಿ ಇವರುಗಳಿಗೆ ನೀವು ಏನೆಂದು ನಿರ್ದೇಶನ ನೀಡಿದ್ದೀರಿ? ನಾನು ಅವರಿಗೆ ಯಾವುದೇ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ನೀಡುವುದಿಲ್ಲ. ಅವರೇ ಸ್ವತಃ ಸೋರವರ ಮನೆಗೆ ಹೋಗಿ ಅವರೊಂದಿಗೆ ಮಾತನಾಡಿರ್ತಾರೆ. This relates to the subsequent offense.
Yes.
Where they brought back the mother and the victim and deleted all the evidence against them. 29 may kindly be seen. This happens on 20th when they bring these 3 people go and bring that lady and the daughter. So and so ಅವ್ರಿಗೆ 2 ಲಕ್ಷ ರೂಗಳನ್ನು ಯಾವ ಕಾರಣಕ್ಕಾಗಿ ನೀಡಿರ್ತೀರಿ? ನೀವು ನೀಡಿದ ಹಣದ ಡಿನಾಮಿನೇಷನ್ ಏನಾಗಿತ್ತು? ಸೋ ಅಂಡ್ ಸೋ ತನಗಾದ ಅನ್ಯಾಯದಿಂದ ತನಗೆ ಬಾಡಿಗೆ ಮನೆ ಕಟ್ಟಲು ಕರೆಂಟ್ ಬಿಲ್ ಕಟ್ಟಲು ಕಷ್ಟವಾಗುತ್ತಿರುವುದಾಗಿ ತಿಳಿಸಿ ಕಣ್ಣೀರು ಹಾಕಿದ್ದರಿಂದ ಆ ದಿನ ನನ್ನ ಜೊತೆಗೆ ಇದ್ದ ರುದ್ರೇಶ್ ರವರಿಗೆ ನಿಮ್ಮ ಕಡೆಯಿಂದ ಏನಾದರೂ ಸಹಾಯ ಮಾಡಿ ಎಂದು ಹೇಳಿದೆ. ರುದ್ರೇಶ್ 2 ಲಕ್ಷ ಹಣವನ್ನು ಆಕೆಗೆ ಸಾಲವಾಗಿ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ದಿಸ್ ಇಸ್ 214 ಡೈರೆಕ್ಟ್ಲಿ ಅಡ್ಮಿಟೆಡ್ ಫ್ಯಾಕ್ಟ್. 30. ನಿಮಗೆ ಭೇಟಿಯಾದಾಗ ಯಾವತ್ತಾದರೂ ಹಣದ ಬೇಡಿಕೆ ಇಟ್ಟಿದ್ದಾರೆ? ಇಲ್ಲ. ಆದರೆ ರುದ್ರೇಶ್ಗೆ ದುಡ್ಡು ಬೇಕು ಅಂತ ಹಾಗಾಗಿ ಬೇಡಿಕೆ ಇಟ್ಟು ಮೆಸೇಜ್ ಮಾಡಿರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಗೊತ್ತಿಲ್ಲ. 31 ಕ್ರೂಷಿಯಲ್ ಕ್ವಶನ್ ಸರ್. ವಿಡಿಯೋದಲ್ಲಿ ಚೆಕ್ ಮಾಡಿದ ಬಗ್ಗೆ ಹೇಳಿರುತ್ತೀರಿ. ಏನನ್ನು ಚೆಕ್ ಮಾಡಿರುತ್ತೀರಿ? ಪಕ್ಕದಲ್ಲಿ ಕೂರಿಸಿಕೊಂಡು ಕೈ ಹಿಡಿದುಕೊಂಡು ಏನಾಗಿದೆ ಎಂದು ಕೇಳಿದೆ. ಮಗು ಆ ಬಗ್ಗೆ ಏನೂ ಹೇಳಲಿಲ್ಲ. ತಾಯಿಯೇ ತನ್ನ ಮಗಳ ಪೋಕ್ಸೋ ಕೇಸಿನ ಬಗ್ಗೆ ತಿಳಿಸಿದರು. ಕೇಸಿನ ಬಗ್ಗೆ ಚೆಕ್ ಮಾಡಿದೆ ಎಂದು ತಿಳಿಸಿರುತ್ತೇನೆ. So that he has checked is an admitted fact.
What is a matter of evidence?
What is a matter is to be ascertained. 36.
Yes.
ಮತ್ತೆ 37 ನಲ್ಲಿ he admits that he has paid 9,000 rupees. 40 ತೆಗೆದುಕೊಳ್ಳಿ. 40. ಅವರು ದೂರು ದಾಖಲಿಸಿದ ನಂತರ ನೀವು ಏನ್ ಮಾಡಿದಿರಿ? ಯಾವುದೇ ಕ್ರಮ ತೆಗೆದುಕೊಂಡಿರುವುದಿಲ್ಲ. 45. This Hiramat is the advocate.
Yes.
To whom she immediately reports the incident, even before confronting the accused. Now that is an admitted fact that he doesn't deny that he is there.
So his defense is ಕೈ ಹಿಡ್ಕೊಂಡಿದ್ದೀನಿ.
Sorry?
His defense is ಕೈ ಹಿಡ್ಕೊಂಡಿದ್ದೀನಿ.
ಕೈ
Nothing
ಹಿಡ್ಕೊಂಡಿದ್ದೀನಿ.
else.
ಹಾ,
That's
ಚೆಕ್
his
ಮಾಡಿದ್ದೀನಿ.
That's his defense.
ಚೆಕ್ ಮಾಡಿದ್ದೀನಿ. ಹಾ, ಅಲ್ಲ ಚೆಕ್
Check ಮಾಡಿ ಹೌದು.
ಕೈ ಹಿಡ್ಕೊಂಡಿರೋದು ನಾಟ್ ಎ ಸಬ್ಸ್ಟಿಟ್ಯೂಟ್ ಫಾರ್ ವಾಟ್ ಹಿ ಡಿಡ್ ಲೇಟರ್.
I'm only telling. That's his defense.
Yeah. Then 46 may kindly be produced. ಏನೇನು ಮಾತಾಡಿದಿರಿ ನೀವು? ಹಾಲ್ನಲ್ಲಿ ಕುಳಿತು ಮಾತನಾಡಿರುತ್ತೇವೆ. ತನ್ನ ಮಗಳ ಮೇಲೆ ಸಂಬಂಧಿಕರು ಅತ್ಯಾಚಾರ ಮಾಡಿದ್ದಾರೆ. ಟ್ರೇಡಿಂಗ್ನಲ್ಲಿ 5,000 ಮೋಸ ಆಗಿದೆ. ಈ ಬಗ್ಗೆ SIT ತನಿಖೆ ಮಾಡಿ ಅಂತ ಕೇಳಿದರು. ಓಕೆ. 48 ತಾವು ನೋಡಿ.
Yes.
ನೋ ಮ್ಯಾಲಿಸ್ ಅನ್ನೋದಕ್ಕೆ ಇವರ ವಿರುದ್ಧ ಏಕೆ ದೂರು ನೀಡಿರುವುದಿಲ್ಲ? ಅಗತ್ಯ ಏನಿದೆ? ಆನ್ಸರ್. ಅಗತ್ಯ ಏನಿದೆ? ಆಕೆ ಈ ಮೊದಲೇ ನನ್ನ ಬಳಿ ಕ್ಷಮೆ ಕೇಳಿದ್ದರಿಂದ, ಆಕೆಯು ಮಾನಸಿಕ ಅಸ್ವಸ್ಥರಂತೆ ಕಾಡುತ್ತಿದ್ದರಿಂದ ಅವರ ವಿರುದ್ಧ ಯಾವುದೇ ಕ್ರಮ ಕೈಗೊಂಡಿರುವುದಿಲ್ಲ. ದಿಸ್ ಇಸ್ ವಾಟ್ಸ್. 51. 2/2/24 ಡ್ರಾಯಿಂಗ್ ರೂಮಿನಲ್ಲಿ ಸೋ ಅಂಡ್ ಸೋ ಅವರ ಮಗಳಿಗೆ ಹಾಲು ಟೀಯನ್ನು ನೀಡಿದವರು ಯಾರು ಅದೆಲ್ಲ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಡ್ಮಿಟೆಡ್ ಫ್ಯಾಕ್ಟ್ ದೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. ಯಾಕೆಂದ್ರೆ ಅದನ್ನ ಡಿನೈ ಮಾಡುವಂತ ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು ಮೊನ್ನೆ. 53. ಮಾಧ್ಯಮಗಳು ನಿಮ್ಮ ವಿರುದ್ಧ ಸುದ್ದಿಯನ್ನು ಪ್ರಸಾರ ಮಾಡಬಾರದೆಂದು ಆದೇಶ ಪಡೆದಿರುತ್ತೀರಿ. ಆದರೆ ಕಂಪ್ಲೇನೆಂಟ್ ವಿರುದ್ಧ ಈ ರೀತಿ ಆದೇಶ ಪಡೆದಿರುವುದಿಲ್ಲ, ನೆನಪಿರುವುದಿಲ್ಲ. ಇಟ್ ಇಸ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟೆಡ್. ಸೊ ಪಕ್ಕದಲ್ಲೇ ಕೂತಿದ್ರು, ಅದೆಲ್ಲ ಅಡ್ಮಿಟೆಡ್. 56 ಈಸ್ ಅನ್ ಅಡ್ಮಿಷನ್. 59 ಅಗೇನ್ ಕೈ ಹಿಡ್ಕೊಂಡಿದ್ದನ್ನ ಒಪ್ಕೊಳ್ತಾರೆ. 63 ಅದು ಇಟ್ ರಿಲೇಟ್ಸ್ ಟು ದಿ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಇನ್ಸಿಡೆಂಟ್. 65 ಯಾಕೆಂದ್ರೆ ದಿ ಗರ್ಲ್ ವಿಕ್ಟಿಮ್ narrates about the details of the room to which she was taken, where she mentions about a curtain, sofas and table. He admits that. 65 ಕರ್ಟನ್ ಇದೆ ಆದ್ರೆ ರೂಮಿಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
So these are the interrogating statements.
Yes.
Yes. Now ಈಗ 164 statement. ಪೂರ್ತಿ ನೋಡಿದೆ. I have seen the whole thing.
Yes. So this is the position. Now why I say the petition is not maintainable. The copies in compilation. ಎದುರುಗಡೆ ಅವ್ರಿಗೆ ಒಂದು ಕೊಟ್ಟಿದ್ದೀರಿ. These are the compilations. I have given all the judgments relating, all the. About POCSO proper, kindly permit me to show. Only 3 of them I have relied. Starts at page 1. Attorney General versus Satish. It's a case where it shook the conscience of the nation, and even the Attorney General was forced to go to the court questioning. What prompted the filing of this petition is a finding recorded at paragraph 5, page 19.
Yes.
Starts at page 19, come to page 20.
Yes.
Subpara 30 may kindly be seen. So the act of pressing the breast can be a criminal force to a woman with the intention to outrage her modesty.
Yes.
Minimum punishment is so and so. 30. It is not possible to accept this submission for the aforesaid reason.
Yes.
Admittedly, it is not a case of the prosecution that the appellant removed her top and pressed her breast. As such, there is no direct or physical contact, that is skin to skin, with sexual intent without penetration. So he was exonerated of the charge. So this is commented upon, and the Honorable Supreme Court had occasion to examine in detail the entire POCSO Act
Yes.
and the analysis of the POCSO Act may be perused
Yes.
at from para 24 onwards. The detailed analysis of section 7 is found at page 31.
Yes.
So there, I'll not trouble the court with the details. In fact, we don't have that problem. There was no allegation that he had inserted the hand in the blouse.
No, here there is.
So that now para 33 sets out the act, the object of the act, and para 34 is important. Kindly permit me to read it.
Yes.
Now, from the bare reading of section 7 of the act, which pertains to the sexual assault, it appears it is in 2 parts. The first part of the section mentions about the act of touching the specific sexual parts of the body with sexual intent. The second part mentions about any other act done with sexual intent which involves physical contact without penetration. Since the bone of contention is raised by the learned senior advocate so and so, with regard to the words touch and physical contact used in the said section, it would be beneficial to refer to it. Now, I'll not trouble the court with that because we don't have that problem in this case.
Yes.
The finding of the court on this aspect may kindly be gathered at page 29 bottom. Placitum H may kindly be perused. The very object of enacting the POCSO Act
Yes.
is to protect the children from sexual abuse. And if such a narrow interpretation is accepted, it would lead to very detrimental situation, frustrating the very object of the act, inasmuch as, in that case, touching the sexual or non-sexual parts of the body of a child with gloves, condoms, sheets, or with cloth, though done with sexual intent, would not amount to an offense. The most important ingredient of constituting the offense of sexual assault under section 7 of the act is the sexual intent and not the skin to skin contact of the child. Then presumption under 2930 referred to in para 39.
Yes.
Para 39. It may also be pertinent to note, having regard to the seriousness of these offenses under the POCSO Act, the legislature has incorporated certain statutory presumptions. Sections 29 permits the special court to presume when a person is prosecuted for committing or abetting or attempting to commit any offense under section 3, 5, 7 and 9 of the Act, that such person has committed or abetted or attempted to commit the offense, as the case may be, unless the contrary is proved. Similarly, section 30 thereof permits the special court to presume for any offense under the Act which requires a culpable mental state on the part of the accused, the existence of such mental state. Of course, the accused can take a defense and prove the fact that he had no such mental state with respect to an act charged as an offense in that prosecution. It may further be noted that though, as per subsection 2 of section 30, the purposes of the said section, a fact is said to be proved only when the special court believes it to exist beyond reasonable doubt, and not merely when its existence is established by preponderance of probability. The explanation to section 30 clarifies culpable mental state includes intention, motive, knowledge of a fact, and the belief in or reason to believe a fact. Thus, on the conjoint reading of 7, 11, 29, and 30, there remains no shadow of doubt that though, as per the explanation to section 11, sexual intent would be a question of fact, the special court, when it believes the existence of a fact beyond the reasonable doubt, can raise a presumption under section 30 as regards the existence of culpable mental state. The next paragraph, placitum E may kindly be seen. The court cannot be oblivious to the fact that the impact of traumatic sexual assault committed on children of tender age could endure during their whole life and may also have an adverse effect on their mental state. The suffering of the victims in certain cases may be immeasurable. Therefore, considering the objects of the POCSO Act, its provisions, more particularly pertaining to sexual assault, sexual harassment, etc., have to be construed vis-a-vis the other provisions so as to make the object of the Act more meaningful and effective. Then conclusion, para 45 may kindly be 44, 45 and 46 may kindly be permitted to be read. In the light of the aforesaid discussion, legal position, the findings recorded by the High Court are appreciated. Clearly emerges that the High Court fell into error in case of the accused Satish in holding him guilty for the minor offense of 342 and 354 and acquitting him of the offense under section 80 of the POCSO Act. The High Court, while specifically etc., 45, placitum B may kindly be perused. So far as section 7 of the POCSO Act is concerned, the first part thereof exhausts a class of act of sexual assault using specific words, and other part uses the general act beyond the class denoted by the specific words. In other words, whoever with sexual intent touches vagina, penis, anus, breast of the child or makes the child to touch so and so, so and so, so and so would be committing an offense of sexual.
Read everything, marked everything.
Yes.
Next judgment.
So this is what the Attorney General case
In compilation, ಮುಗಿಸ್ಬಿಟ್ಟೆ.
referred to the court. Justice Ravindra Bhatt ಅವ್ರದ್ದು ಜಡ್ಮೆಂಟ್ ಇದೆ ಕೇಸ್
Manoj versus Soames.
ಬಹಳ ಅದು ಚೆನ್ನಾಗಿದೆ. ಅದು
That's elaborate
much more emphatic.
Yes.
Then
Importance of forensic.
yes, kindly come to page 47. Delay, court was pleased to ask me,
POCSO.
how do I, ಇದರಲ್ಲಿ 6 months delay. 6 months delay and
POCSO cases, sometimes there is a delay of 1 year also which is taken note of.
yes,
And it is said.
yes.
The judgment in Gurmeet Singh's case takes care of it.
And para 7.
Direct judgment, you're talking of Rajiv Kaurav.
ಹೌದು.
That's what I referred on the other day. I myself followed and held. 161 statement ಮೇಲೆ para 8 and 10 of Rajiv Kaurav, if you see.
ಇದೆ ತೋರಿಸ್ತೀನಿ ಅದನ್ನು ತೋರಿಸ್ತೀನಿ.
Para 8 and 10 of that judgment.
ಹೌದು.
which says the High Court had relied on 161 statements and quashed the proceedings under 482.
ಮಾಡಕ್
At
ಬರಲ್ಲ.
para 10, Supreme Court says that relying on 161 statement and quashing the proceedings under 482 is not available.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಮೋರ್ ಎಂಫ್ಯಾಟಿಕ್ ಗ್ರೌಂಡ್ ಇದೆ.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ-
ಮಚ್ ಮಚ್ ಮೋರ್ ಎಂಫ್ಯಾಟ್. ಇದ್ರಲ್ಲಿ ತಾವು ಒಂದ್ ನಿಮಿಷ ತಾವು
ಯಾವ್ದು?
ಪ್ಯಾರಾ 11, 12 and 13 ಪರ್ಮಿಷನ್.
Page ಇದ್ರಲ್ಲ.
ಪೇಜ್ 50 ಇದೆ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ.
ಹಾ.
In our considered opinion, observations made in para 9 of the impugned order are totally unwarranted, have been made overlooking the specific allegations contained in the FIR, duly supported with the statement of the victim girl child under section 164. This is very important. Importance of this. Then 12. Sir, this applies both to the anticipatory bail application that has been filed, which is also, yeah, ತಮ್ಮ ಮುಂದೆ ಇದೆ.
ಅದು ಇದೆಯಾ?
ಹೌದೌದು, ಅದ್ರ ಮುಂದೆ ಇದೆ. It directly applies to that. So here itself I will point out, para 12. In a case containing such serious allegations, High Court ought not to have exercised its jurisdiction in granting
protection
against arrest. As the investigation, without saying that appearance before the investigating officer, who has been prevented from subjecting respondent 1 to custodial interrogation, can hardly be fruitful to find out the prima facie substance in the allegations which are
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗೋಗಿದೆಯಾ?
ಇದರಲ್ಲಿ
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗೋಗಿದೆ.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ. ಆದ್ರೂ ಕಸ್ಟೋಡಿಯಲ್ ಇಂಟ್ರಾಗೇಷನ್
ಚಾರ್ಜ್ ಶೀಟ್ ಆದ್ಮೇಲೆ
it would have been much more fruitful. That's all what I'm saying.
when it was
Yes, it would have been much more
when
fruitful.
the
You would have
coordinate,
been
when
more
the coordinate bench interdicted.
Yes. ಯಾಕೆಂತಂದ್ರೆ ನಾನು ಇಂಟ್ರಾಗೇಷನ್ ವಾಟ್ ಐ ಡಿಡ್ ನಾಟ್ ಶೋ ಇಸ್ ಮಾತು ಹೇಳಿದ್ರೆ ಅವರು ಇಲ್ಲ ದುಡ್ಡು ಕೇಳಿದ್ರು ಅದನ್ನ ನಾವು ಪ್ರಶ್ನೆನೇ ಕೇಳಿಲ್ಲ ಅವರು ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅವರು. ಆದ್ರೂ ಪ್ಯಾರಾ 13 may kindly people. So it would have been much more. So can hardly be fruitful to find out the prima facie substance in the allegations which are of extreme serious nature. The fact that the victim girl is traumatized to such a high degree that her academic pursuits have been adversely impacted alone, coupled with the legislative intent, especially reflected through section 29 of the Act, are sufficient to dissuade a court from exercising discretionary jurisdiction in granting pre-arrest bail.
Yes.
It may be true, as pointed out by the learned counsel appearing for respondent students. Charge sheet has already been filed. So here also charge sheet has already been filed. It will be unfair to presume on our part that the investigating officer does not require respondent 1 for custodial interrogation for the purpose of further interrogation. So this case it applies. Kindly come to para 16, very serious nature. So I'll not trouble the court with the rest of it.
Yes.
They are general in
I will.
nature. Now next case, sir, that is a very important case. Just rights for children.
Yes, that is Justice.
There is an exhaustive
Chief Justice.
review
Yes, yes.
of case law. It is
ಇದರಲ್ಲಿ settlement ಮಾಡಬಾರ್ದು. All that is said.
Justice Pardiwala's judgment.
Yes.
It was relating to pornographic this thing, and the High Court had quashed the proceedings.
That is Madras High Court.
Yes. Now the entire POCSO law is reviewed
Yes,
from
yes.
page 66, para 39.
Yes.
Page 66 may kindly be perused.
Yes.
There is a detailed
No, that
narration.
runs up to 165.
Yes.
Is that
160. Yes.
lengthy order?
Very, very lengthy order, very detailed
Yes,
consideration.
that is importance of POCSO.
Yeah, importance of POCSO. 51 is especially important.
Yes.
Presumption is
Yes.
highlighted. 53, the case law is reviewed from
Yes.
53 onwards. I'll not trouble the court with the case law.
Yes.
There is a very important section in this paragraph, in this section, which relates to the aspect of the final finding may kindly be perused. IT Act is reviewed there afterwards. Sir, kindly come to the presumption part of it. Sections 29 and 30 are dealt with.
Para one eighty-five
Page
to 190.
154.
Para 185.
Well, I'll come to 185. Page 154, it starts.
Finally, at
Yes, yes.
para
Yes,
190
yes.
and 194.
Yeah, one. I'm obliged for that observation. Now, what is statutory presumption? What is its impact? It has been examined in detail. 185, I'll read 185, page 128. From the exposition of law, it is clear. There is no bar for the High Court to invoke statutory. The reason why this came. Now, section 29 uses the special court shall presume. So it is only for the special court for that presumption,
Scope is expanded here.
not under 482. So this was the argument. So therefore, the court had this to
That's
say.
good. Scope is
There is no bar for the High Court to invoke the statutory presumption at the stage of deciding quashing petition in respect of any offense to which such a presumption is applicable. Rather, any failure to give due weightage to the same may result in dire consequences such as premature quashing of the criminal proceeding or allowing an accused to completely bypass the statutory presumption, which otherwise would have been applicable at the trial. In the light of our earlier discussion, and without again referring to the plethora of decisions, it is clear how the statutory presumption plays a vital role when it comes to offences such as those under the POCSO. This court in Attorney General held that considering the objects of POCSO, its provisions, etc., any selective reference to a particular provision in complete ignorance of the other provision would result in mutilation of the entire scheme and purport of the legislation, and thereby defeat the purpose for which it was enacted. The High Court, as a matter of choice, kindly mark this.
Yes.
The High Court, as a matter of choice, should not shy away from referring to the statutory presumption that has been incorporated in the Act whilst deciding a quashing petition. The High Courts must not deal with a particular offense under any enactment devoid or in disregard of the rest of the statutory framework. It must recognize and refer to the legislation in total. Otherwise, it would give an undue advantage to an accused by allowing him to mischievously prefer a quashing petition before the trial commences, completely bypass the statutory presumption provided by the legislature, walk right away from the criminal proceedings, thereby setting the entire legislation at naught. It is imperative for the courts to discourage any such attempts on part of the accused to short circuit the statutory provisions and procedure laid in a particular act and evade trial entirely. In such situations, the statutory presumption becomes all the more important to effectively ensure that such criminal process is not manipulated in by any devious accused. In Prakash Nath Khanna and Ratish Babu Unikrishnan, any defense of the accused for the purpose of rebutting said statutory presumption should ordinarily be left to the trial court to be looked into, at least when it comes to quashing petitions. Though in certain exceptional cases, High Court may do so and so, so and so, so.
That is always there.
Bogus, it is there. But in doing so, the High Court must be slow and circumspect, must exercise some restraint. The statutory presumption may be ignored only where no foundational facts have been established from the material on record. Once the foundational facts are prima facie established from the material on record, it would be improper for the High Court in a quashing petition to conduct an intricate evidentiary value into the facts and ascertain whether the requisite mental elements are present or not. All these aspects should be left to be decided by the trial court, which is the appropriate forum.
Yes.
190. When the High Court quashes any criminal proceeding without considering the legal effect of the statutory presumption, it effectively scuttles the process of trial thereby denies the parties the opportunity to adduce appropriate evidence and the right to a fair trial. This would not object. This would not only defeat the very case of the prosecution, but would also thwart the very object of particular legislation and thereby undermine the public confidence.
Yes, we'll go to the next one.
Yeah. So this is what,
On POCSO, Aito.
yeah,
Now this is Rajiv Kaurav, page 165,
yes, 160.
para 6,
Yes,
last 5 lines of para 6, para 8 and para 10.
yes. I've also placed authorities by this honorable court.
Yes, Niranjan Hegde's case.
Yes,
I
where
myself
once
raised.
the charge sheet is filed, the accused should be relegated to,
No, that is D. Ravishankar, Justice Dikshit ಅವ್ರದ್ದು.
so, ತಮ್ದು ಇದೆ judgment.
ನಂದು ಇದೆ ಇಲ್ಲಿ.
Yeah,
That is at
ನಂದು ಇದೆ.
page 199.
Yes, yes. So,
That was a case of dowry death.
Rajiv Kauravdu,
Rajiv Kaurav, yes,
Yeah.
straight away. That is
161 statement,
that is what you
direct
said,
authority,
direct on the.
direct authority.
ಅದು ನಾನೇ ಹೇಳಿದ್ದು ಇವತ್ತು.
ಹೌದು.
16 ರಾಜೀವ್ ಕೌರವ್
ಅವ್ರು-
ಇದೆ.
ಅವ್ರಿಗೆ ಮಾಡ್ಬೋದು ಅಂತ. There is a direct authority, para 10 is sufficient.
Yes. And in Iqbal's case, Supreme Court said, Justice Pardiwala said, once charge sheet is filed, remedy is discharged.
So,
Exceptional cases, this court can interfere. Then you're relying on Justice Dikshit or the case
Okay.
of where this page 476,
472.
right to telling power of cost so and so.
Sidramaia's case itself
Sidramaia's
is an
case,
authority. It was relied upon.
Yes. So there again,
Then cognizance on which my learned friend has very elaborately argued. I have given any number of judgments.
yes,
That is in volume 2,
yes.
first section.
So there are two ways.
Sole
that-
testimony of the victim can be the basis for conviction. Not only,
So at least there should be trial is what you say.
yes, therefore, that is given in section, second section of volume 2.
Yes, yes.
I give a number of cases.
Yes, yes.
Delay, it has no application to
Gurmeet Singh ಕೊಟ್ಟಿದ್ದೀರಾ?
case of sexual offences. That also I have given. Malafides, I have also shown there are no malafides.
There is one judgment.
And one factor, court may kindly consider this.
Yes, sir.
Now 14.3 FIR is lodged. 19.3 he goes to court, obtains an ex parte injunction against 73 defendants who are all media houses.
Oh,
Not a whisper of political motive, not a whisper of any malafides. And more importantly, the complainant is not made a party to that OS.
in that way.
Yes, I have placed that plain copy also in the matter.
Now, with all this, according to you, their delay will not inure to the benefit of the petitioner for quashment. These are matters of trial and it's case of POCSO, where this court should hold its hands in quashing the petition when there is prima facie evidence.
And raise a presumption,
Prism, that-
29 and 30, direct presumption that
that's
he is guilty. And I have shown how a guilty mind has operated at every step, interrogation,
question on
confrontation.
the mobile recording is.
Mobile recording clinches the issue, if I may say so. with respect.
That's.
One last thing before I conclude. This is a gross abuse of the process of the court for the simple reason. Sir, kindly note one important date. The petitioner was keeping silent without raising his voice, without protesting against what she had done, without even proceeding against her till her death. She died on 26/5/2024. In all probability, the petition to file was ready, but they had their own apprehension. Now kindly come back to the writ
When was
petition,
it- when was it-
memorandum of writ petition for a minute.
Was it filed
At 12/6 it was filed.
after the death?
Waiting for the death. Why I say so, kindly look at the affidavit.
Of the petition?
Yeah. Of the memorandum of writ petition, original petition may kindly be. Sir, it is dated 12/6/2000. Petition is dated 12/6/2024.
Hmm.
And it is sworn to by an affidavit which was 1 week earlier. 1 month, 1 week earlier, 5/5/2024.
So it was not kept ready to be filed.
Sir, what I am saying is, this is not a petition verified by that affidavit. This petition should be thrown out lock, stock and barrel on this simple ground. There is no verification. Because this refers to the developments in June, when notice was issued, annexures E and F for his appearance. That was in June. So it is a calculated effort on the part of the petitioner to move the court immediately after the death of the complainant.
We'll consider.
And having said all this, I request the court to kindly take note. Incident occurred on 2/2. We are almost 17 days away, just 17
For a
days
year.
away from 2/2, which is the mandatory requirement under the act.
Before that, you will get the order.
Ah,
Yes. Yes,
Big-
17th? Sir is coming on 17th, right?
Civil suit to page 161 ಅಲ್ಲಿದೆ.
Charge sheet ಅಲ್ಲಿ ಇದೆಯಾ?
Additional charge sheet ಅಲ್ಲಿದೆ.
ಕುಡಿಯೋದು. ಹೆಚ್ಚುವರಿ ದೋಷ.
Sir, we have tried our best to present our case. Nearly 20 dates list ಆದ್ರೂ we did not get an opportunity to present.
ಇವತ್ತಾಗಿದೆಯೋ ಇಲ್ವೋ?
ಇವತ್ತಾಯ್ತು. ಇವತ್ತಾದ್ರಿಂದ ಇವತ್ತು ನಾನು ಏನ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೋತಿದ್ದೀನಿ ಅಂದ್ರೆ, ಇವತ್ತಿಂದ ಡಿಸ್ಕಂಟಿನ್ಯೂ ಹಿಸ್ ನಾನ್ ಅಪಿಯರೆನ್ಸ್.
See, I have heard and I will hear him on 17th.
4 ದಿವಸ ಅವ್ರನ್ನ ಹಿಯರ್ ಮಾಡಿದಿರಿ.
ಅಲ್ಲ ಮತ್ತೆ ಇವತ್ತು only 1 hour on that day,
Please.
not more than that. We'll finish it before 2/2/2025.
ಅಲ್ಲ
Definitely.
ಟ್ರಯಲ್ ಮುಗಿಬೇಕು.
Let-
ನಿಮ್
I'll move
proceeding
that.
ಅಲ್ಲ.
We'll see. We'll pass our order.
And
Before that date.
what shocked me, my conscience, I'll share it. Earlier I had said it. My learned friend put a question to himself saying that because of delay, I am trying to meet the delay, and that the interim order was made without hearing the prosecution. No, the interim order was made after hearing the learned advocate general. I was not on record. And I ascertained this from, sir, 55 years I have been a student of law. 50 years I am a lawyer. 45 years I have taught law. It is unheard of. I believe the learned advocate general confirmed this to me. Therefore, with all responsibility and humility at my command, I make this submission. It appears the judge asked before passing the interim protection, is he a Tom, Dick and Harry? So this jurisprudence is unknown. Tom, Dick and Harry jurisprudence is unknown to law.
All right, that's-
I am extremely saddened by that kind of an observation, which is the basis for the interim order.
Previous bench.
ಅಲ್ಲ ತಾವು ಅದನ್ನ ಹೇಳಿದ್ರಿ,
ನಾನ್ ಹೇಳಿದೆ.
ಕಂಟಿನ್ಯೂಯೇಷನ್ ತಾವು ಹಿಂದಿನವ್ರು ಮಾಡಿದ್ದು ಅಂತ ಹೇಳಿದ್ರಿ,
ಹೌದು.
ಬಟ್ ಕಂಟಿನ್ಯೂಯೇಷನ್ ಇಸ್ ಈಕ್ವಲ್.
That's all right. I have never said those statements. According to me, however high they are, the law is above them.
That
That's
is
all.
precisely. Be you ever
That's
so
all.
high,
It
the
can't,
law is above you is the well-known adage.
according to me, that is the thing. Yes.
204 to 2 ಇದ್ರ ಬಗ್ಗೆ
204 to?
he also made a submission that cognizance under 204 and 214.
No, for offenses under section 214,
Yes.
204 and 214.
Yeah.
That is against the others in the companion petition,
You
not against
accused one ಅಲ್ಲ.
Yediyurappa. Not against Yediyurappa. Others we will see.
ಅದನ್ನ ಹೇಳ್ತೀನಿ ಬೇಕಂದ್ರೆ ಅವ್ರು ಮುಗಿಸ್ಲಿ
ಅದ
ಆಮೇಲೆ.
ಮುಗಿಸ್ಲಿ ಅದ್ರಲ್ಲಿ ಏನು ಅವರಿಬ್ಬರದ್ದು petition ಅಷ್ಟೇ ಅದು 204
ಅದ್ರದ್ದು
214.
ಸಪರೇಟ್ ಎವಿಡೆನ್ಸ್ ಇದೆ, ಅದನ್ನು ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
All right.
ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಅನ್ ಅಡ್ಮಿಟೆಡ್ ಫ್ಯಾಕ್ಟ್. ಹಿ ಸೇಸ್ 2 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ ನಿಜ ಅಂತ, ಸಾಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಯಾರಿಗಾರು ಕೊಟ್ರ ಅಂತ ಕೇಳಿದ್ರೆ ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ, ಇದೆ ಫಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದು. ಅಂಡ್ ಹೋಲ್ ಥಿಂಗ್ ಆಫ್ಟರ್ ದಿ uploading of the complaint, she complains to the President of India, to the Union Home Minister, to the Police Commissioner, to the DGP, everything on record. And in this age of digital this thing, she uploads immediately after the confrontation and 2/2 itself. Where is the question of delay in this? Please.
But the earlier order for granting, you said Tom Dick, it's the way of putting it. No fault can be found with.
Great respect, such observation should not come from the mouth of a constitutional court. With all humility, I
Way of-
submit, because that gives a wrong signal. I don't know whether the court had.
The Lordship is so erudite that sometimes. yes.
I have no doubt about it. But
Absolutely.
that was the saddening part, that it came from his mouth.
Sometimes
I-
it happens.
Yeah.
Was the most erudite judge of this court. 17th. Ata online bandra sir.
Please.
Yes.
My lords,
Heard
I
the
said-
learned senior counsel, Professor Ravi Verma Kumar, who completes his submission in writ petition 15522 to hear learned senior counsel C.V. Nagesh list the matter on 17th. Only 1 hour.
ಆಂಟಿಸಿಪೇಟರಿ ಬ್ಯಾಲ್ ಬಗ್ಗೆ ಜಸ್ಟಿಸ್ ಫಣೀಂದ್ರ ಅವ್ರದ್ದು ಒಂದು ಜಡ್ಮೆಂಟ್ ಇದೆ.
ಅಲ್ಲ.
ಡೈರೆಕ್ಟ್ ಆಗಿ ಬರಂಗೆ ಇಲ್ಲ.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗೋಗಿ.
ಹಾ,
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗೋಗಿದೆಯಲ್ಲ ಈಗ.
ಆಗಿದ್ರು ದಟ್ ಇಸ್ ವೈ ಐ
So that judgment yes will
Delayed.
consider.
ಕಸ್ಟೋಡಿಯಲ್ ಇಂಟ್ರಾಗೇಷನ್
Custodial interrogation would be required.
ಮೇಬಿ ಐ ಡೋಂಟ್
That's
ನೋ.
what. Charge sheet ಆದ್ಮೇಲೆ we'll consider it. Yes.
My lords,
Please.
may I request it at 2:30, madam?
2:30 ಆಗ್ಬೋದಾ?
Please.
2:30, even if it is 7 o'clock, you should finish
Please,
that
madam.
day.
My lords, the interim order.
That will continue.
Please,
Yes.
oblige.
Grateful.
Come back to. ಅಲ್ಲಿ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ ಆ list. Come back to the main list. Dharwad list.
The Lordships kindly. With the Lordship, I'm sorry to interfere, my lord.
I think court is muted, my lord. In this Zoom call, it is muted, my lord.
Here's the idea.
Audio video ಯಾರ್ದು ಮ್ಯೂಟ್ ಆಗಿರೋದು?
Yes, Lord. Now you can hear, my lord.
We don't know whether your Lordships are in Bangalore, my lord.
I'll get
List.
back to that list. Wait, sir.
Very well, my lord.
We'll
Very,
come at 2:30.
very well, my lord. 2:30.
Court officer.
Court officer. Court officer.
Yes.
Page
Decree
64.
partition. Where is the